Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It is a rare occasion that I actually get to shoot a video in the middle of the afternoon. Breaking news today. Actually was able to clear off part of my calendar, because as some of you know, I do run a full-time law practice here. But Hunter Biden has been indicted on not one, not two, but count it, 3 felony charges, all related to an unlawful purchase of a firearm. But what does it all really mean? I know there's a lot of people out here in the YouTube sphere and everywhere else on social media claiming they know what they're talking about and this is what's going to happen and all that. Let's just try to boil it all down to some true, simple facts and let's talk about it. Let's get you all educated. So today, let's spend a few minutes and let's talk about Hunter Biden indicted. But what does it really mean? Okay, Dateline, September 14th. This is what we're talking about. Hunter Biden, who had a sweetheart diversion agreement at one time on these charges, has now been indicted by the Department of Justice on 3 separate felony accounts, all related to a purchase of a Colt Cobra handgun in 2018. Now, apparently in 2018, Mr. Biden was struggling mightily with his drug addiction, but was still able to purchase that firearm because he lied on all of the applications, and then managed to out himself in his own memoir and biography. Fantastic work, Hunter, seriously. Now, let's break down the 3 felony counts, because I want you to understand, because there's a lot of people out there saying, well, hey, you know, they're just going to argue that this law is unconstitutional based upon the Fifth Circuit ruling in Daniels, which we're going to talk about. But I want to explain to you that even if that argument is successful, it's not going to help Hunter Biden that much, and I'll explain why. Okay, count 1 of the complaint is that Mr. Biden violated 18 United States Code Section 922A6, as well as 18 United States Code 924A2. What is that? That is that he lied on a Form 4473, which is exactly what he did, okay? There's a question on there that says, are you an illegal user or addicted to any controlled substance as defined by federal law? He clearly marked that he was not, when at such time he in fact was. That is lying on a Form 4473, and that is count 1, okay? Now, count 2 is a violation of 18 United States Code Section 924A14. What is that? Well, that is that you lied to the FFL. So this is the same lie, but in a different form of communication. This is lying to the gun dealer who sold him the firearm. It is unlawful to lie on a Form 4473. It's also unlawful to lie to a licensed FFL. That is count 2. Count 3. Now, that's a violation of 18 United States Code Section 922G3 and 924A2. Now, this is the one that says it is unlawful to be a user or addicted to a controlled substance while possessing a firearm, okay? Now, this is the one charge that is actually subject to the holdings of United States v. Daniels. United States v. Daniels, as you may recall, we talked about it on this video right here, is a case that recently came out of the Fifth Circuit, that Daniels was a cannabis user. There was no evidence to suggest that he was ever a danger to anyone, and what the court did in striking down that statute said is there is no historical tradition for a blanket ban against just a user. There is a historical analog of banning possession of firearms while the person is actually in a state of intoxication, regardless of the substance, alcohol being the most frequent one that we look back in the historical analogs. But there is no blanket ban on a person being a user of a substance and yet not being able to possess the firearm in any way, shape, or form. Now, here's the interesting thing that's going to happen. You're going to have Hunter Biden's attorneys arguing that 922G3 is unconstitutional, while President Biden's Department of Justice is going to be in court saying the hell it ain't. Of course it's constitutional. This is the way we've always done things. Those drug users, they're bad and dangerous people. But here's the thing that the Biden legal team needs to be aware of, okay, is that even if you're successful on that challenge, that gets rid of count 3 of the complaint. It does not get rid of count 1. It does not get rid of count 2, because the crime there is not being a druggie and possessing a firearm. The crime there is lying on a federal form and lying to an FFL. And that he did no matter what. He already lied on those forms. The crime is committed and completed. It is a fait accompli, if you would, at the time that the lie was made. So even if Daniels ultimately throws out Section 922G3, It's not going to throw out 922A6. It's not going to throw out 924A2. It's not going to throw out 924A14. And those are all the other federal statutes under which Hunter Biden is being indicted today. So to suggest that there is going to be some constitutional out for Mr. Biden, it's just not the case. He might be able to escape count 3, but that is it. Now, what do I believe is going to happen? Well, unfortunately, until I see differently, I believe that there is a two-tiered justice system. There is the system for those on the political inside, typically with a D next to their name, and the rest of us, okay? If you go back and you just Google how many times people have been busted for this, and you take a look at the typical sentence that is handed out, yes, people almost always, and I do mean almost always, serve not only jail time, but prison time for this. Now, the maximum penalty is 10 years in prison and $250,000 a fine. Am I suggesting that Hunter Biden should get 10 years in prison for this? I'm actually not. No, I don't think anyone else in a similar situation deserves to be incarcerated for 10 years for that. But I am a huge fan of equal application of the law, okay? It makes my job easier to try to explain the law to people when there's actually an equal application of it, okay? And if we're gonna have an equal application of the law in this instance, Mr. Biden, you're going behind bars for a while. Listen, we're going to do follow-up videos as everything becomes a little bit more clear. Obviously, this is going to be a drama that will unfold that will be quite interesting. It'll be a little bit like a soap opera, so we will keep you apprised. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, let's all remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to 1, not lie on a Form 4473, and 2, to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.